Hello. Hello.
Yes, sir.
Brother, ಕೇಳತ್ತಲ್ಲ?
Yeah, perfect ಇದೆ sir. ಈಗ
Correct ಐತಲ್ಲ?
correct.
Audio video okay ಅಲ್ವಾ?
Yes, sir. Yes, sir. Yes, sir.
Okay, right. Thank you. 11 o'clock correct start ಮಾಡಿ.
Yes, yes, sir.
Okay.
ಮತ್ತೆ ನಂದ ಬ್ಯಾಟ್ರಿ ಚಲೋ ಬರುತ್ತೆ ಮತ್ತೆ ಇದು ನೆಟ್ವರ್ಕ್ ಚಲೋ
ಹಾ
ನೋಡ್ರಿ ಸರ್ ಬರಾಕತ್ತಾನ ವಾಯ್ಸ್. ಇಷ್ಟೆಲ್ಲ ಬರ್ತೈತಿ ನಮ್ಮ ಹುಡುಗರು ಬಂದು ಮಸ್ತ್ ಪಡ ಮಾಡ್ಬೋದ್ರಿ ನಂಗೆ.
ಏನ್ ಬರತ್ತಿಲ್ಲ ಮಾಡಿಲ್ಲ ವಿಡಿಯೋ ಅಷ್ಟು ಆನ್ ಇಟ್ಟ ಇವೇನ್ ಹೆಂಗ್ ಹೇಗ್ ಮಾಡ್ಕೊತಾವ್ರಿ ಇದೇ ಇದ್ರದನ್ರಿ ಇದು ಲೈಟ್ ಬಂದ್ರೆ
ಸರ್
Hello everyone and welcome to one-day national level seminar on admissibility and relevancy of evidence. My name is Harsha SM and I will be your moderator. I work as an assistant professor of Saraswati Law College, Chitradurga, and I am excited to be hosting this session today. Relevancy and admissibility are the two sides of the same coin. The expression relevancy and admissibility are often taken to be synonymous, but they are not the same. Their legal implications are different. All relevant facts may not be the admissibility, but all admissible facts are relevant. In this view, I am pleased to introduce today's speaker, Dr. M.K. Matolli, who was a gold medalist in LLM and has secured MA in economics. He is a scholar in various subjects. He has published more than 30 articles in national and international journals. He has delivered many talks on various subjects in state and national level seminars and conferences as a resource person. Before I hand the mic over, I have a few housekeeping items to cover about this presentation. First, we would love to hear from you during today's presentation. If you have a question to our speaker, please feel free to send it through Ask a Question tab at the bottom of your player. We will be answering questions at the end of the session. Next, today's seminar will be available on demand after the live session in YouTube. And last, we will be providing e-certificate to the audience. All you have to do at the end of the session is you have to fill up the feedback form in the given link. So without any further ado, I would like to kick things off by welcoming Dr. D.B. Ravi Kumar, Assistant Professor of Saraswati Law College, to deliver welcome speech. Over to you, sir.
Good morning to all. I, Dr. D.B. Ravi Kumar, Assistant Professor, Saraswati Law College, Chitradurga. Today, Saraswati Law College is organizing one-day national level seminar on admissibility and relevancy of evidence. Today's distinguished speaker is Dr. M.K. Matolli, Assistant Professor, Government Law College, Hassan. On behalf of Saraswati Law College and all the participants, I heartfully welcome you, sir. I also welcome our distinguished principal and director of this seminar, Srimati M.S. Sudhadevi, Madam. I also welcome all the participants of various law college and participants to this seminar. Finally, I also welcome our college teaching and non-teaching staff and students for this seminar. Thank you, one and all. Thank you, sir.
Thank you for the warm welcome, sir. Now I request our esteemed guest, Dr. M.K. Now I request our esteemed guest, Dr. M.K. Matolli, sir, to share some knowledge on admissibility and relevancy on evidence. Over to you, sir.
Thank you. At the outset, I am privileged to be part of this Saraswati Law College, Chitradurga, to deliver this lecture on admissibility and relevance of evidence. For this opportunity, I thank Principal, Madam Sudhadevi, and also the management and my esteemed colleagues, Dr. Gowda, Ravi Kumar, and all young colleagues. I'm thankful to all of you. To the extent possible on my part, let me throw light on this crucial procedural issue in the law of evidence. The other instructions are already issued to the participants. Presuming that those instructions are kept in mind, let me complete my presentation first. Okay, this topic, admissibility and relevance of evidence. At the beginning itself, the anchor was telling that they are the sides of two coins, and the relevance, the fact which is relevant may not be admissible, and all the admitted facts are always relevant. That is being the statement, but that may also be correct in all the circumstances, because the procedural law is so much vast that this evidence, sometimes what happens is, even though some evidence is admitted, that it may not be relevant also. That is also possible. I will come to that aspect in the course of my lecture. Let me begin with, since there are many students and also we are in the middle of this pandemic, we don't know what is happening to the examinations and all. So amongst all these things, let me be useful to the students as well, because many of the students have been logging in here. Okay, what is evidence and what this law of evidence is? Law of evidence is called as lex fori. Lex fori means it is the law developed by the courts of the nation, and it is a procedural law dominantly. It can't affect the substantive rights of fact, but there are some substantive provisions. So for the most part of it, law of evidence is the procedural law, and there are some substantive provisions in it. And what is evidence for a layman? Then what is evidence for the people we, that is law people? What is evidence? Evidence means, or evidence is nothing but the means by which the facts claimed are established. In every suit or proceeding, what happens is the facts are claimed to be in existence or not to be in existence, whether it is civil or a criminal case. For both the cases, evidence is common in the sense there is a stage called as evidence. In civil cases, certain facts are asserted and certain facts are denied. And how to prove those facts? The answer lies in the law of evidence. So, evidence is nothing but the means by which the facts are established before the court or proved before the court. So, people say that the evidence is nothing but the means of proving the fact. That is the simple meaning which we can assign to the term evidence. With that meaning, now there is another term, adducing evidence. Adducing evidence means it is producing the evidence before the court or presenting the evidence before the court. That term also we should be conversant with. Then what happens in the course of evidence, the course of law is, what we are trying to do in the court of law during the stage of evidence is, we are convincing the court about the facts. How to convince the existence of facts? We should convince the facts to the court in such a way that they have happened like this. It means, in a way, there has to be a concoction, a systematic concoction before the court, because the judge or the court must realize as to what had actually happened, so that we can get a judgment in our favor. So this is a very crucial task in the conducting of cases before the court. So this is the concoction in a way. In concoction, what we do is we convince the court. It is not the falsity. We are showing the court as to what the court had, what the facts, how the facts had happened. For example, an accident took place. How the accident took place? We concoct the story. We bring out the map. We bring out the different things, distance and all. So we try to concoct the things before the court and convince the court. That is the process of giving evidence. Now this evidence, it can be classified into three categories. In most of the statutes, we find the definition clause under section 2, but in evidence we find section 3 as interpretation clause. It is not definitional clause, it is interpretation clause. What this section 3 says is, it defines evidence. Before I come to that evidence, when we discuss this law of evidence overall, we can say that there are three categories of evidence. One is oral evidence, the other is documentary evidence, which I am dealing with now, in my very next few words. The third one, real evidence. Oral evidence. When the witnesses come before the court and make statements, that is oral evidence. When the documents are produced before the court, there is documentary evidence. Then there are certain things which are neither oral nor documentary, but still they also play a very important role, like the knife used in the offense, or the weapons used in the offense, or the stolen property in theft cases. These are all called as real evidence. So evidence can be classified into three categories, though definitionally we can say that there are only two categories of evidence. Okay. Now, this evidence, as I said, the entire law of evidence can be dealt with in four angles. One angle is, as I said, it has got three categories: oral evidence, documentary evidence, and real evidence. The second angle is, evidence is a fact-finding process. It means the court is encountered with the problem of answering the question whether a fact has happened or not, and this evidence answers whether that fact has happened or not. So in that way, evidence acts as fact-finding mechanism. Then the third angle is evidence may act as premise to draw certain inferences. So in evidence, we prove certain facts by which not that certain facts which are in issue are proved, but certain inferences regarding the fact in issue are proved. So this we call as the relevant facts. So evidence, law of evidence is concerned with the relevant fact in the third angle. In the second angle, the law of evidence is concerned with the fact in issue. And fourth one, we are coming to the today's topic, we are concerned with the legal concept of evidence. Legal concept of evidence means for a layman, evidence is one thing, but for law people, evidence is specific. It is just the legal evidence, legal concept of evidence varies. That is admissibility versus relevance. So this I am going to deal with in my entire lecture. Okay, with this background about the topic, let me come to the concept of evidence first. After resolving that concept, let me take you to the other things called as this relevancy and admissibility. Section 3, as I said, it defines evidence, or it interprets the clause evidence. What is evidence? As I said, two categories. Evidence means and includes. The very title of all interpretation says means and includes. It means these are not exhaustive definitions. Not that these included things only are those things. There may be other things also. So these are not the exhaustive definitions. Like that, evidence means oral evidence and documentary evidence. Not that the real evidence is not evidence at all. There is also evidence because it means and includes. It also includes the real evidences like the weapons used, the property stolen and all under this category. So means and include. Okay. Evidence means all statements. See, I'm telling it in simple terms. Evidence includes two things, as I said, oral evidence and documentary evidence. First one, oral evidence. What is oral evidence? Oral evidence means all statements. Statements are made by whom? Statements are made by the witness. Where they are made? They are made before the court in the capacity as witnesses. So they are the statements before the courts by the witnesses, and all importantly, in relation to the matters of fact under inquiry. So the evidence means that is a statement by the witnesses and all, and that statement must relate to the fact in inquiry. Fact in inquiry, matter of fact under inquiry means the statement must be relating to the fact which is in issue or under inquiry. So this again in the light of provision of section 5, we can again discuss that. So this is the first thing, oral evidence. So oral evidence means all statements, they must be necessarily have been made by before the court of law in relation to the matters of fact under inquiry. That is oral evidence. Not documentary evidence. What is documentary evidence? Documentary evidence means documents, all documents produced for the inspection of the court. After the amendment of the Evidence Act, after the advent of the Information Technology Act 2000, documentary evidence means all documents, including the electronic documents, produced for the inspection of the court. Again, this document must also relate to the matters of fact under inquiry, though it is not stated in the clause 2, because we have to convince the court as to how it is relevant to the fact under inquiry, because that is necessary by virtue of different provisions under the Indian Evidence Act. So these are the two things. All documents produced for the inspection of the court. That is documentary evidence. Now we think that the definition of evidence is over with this, but it's not so. The definition of evidence is very comprehensive. In the sense, in the first, we refer to the fact that the statements must relate to the matters of fact under inquiry. What is a fact? This is very crucial. What is a fact? Fact is also defined or interpreted under the same clause. Fact means and includes, again, the same wording before the definition. Fact means and includes anything, state of things, relation of things. So that there are three things to understand the meaning of fact. Fact means anything you are witnessing, anything you are seeing, anything you are perceiving is a fact. So this is land. That is a tree, it is a fact. It is a table, it is a fact. That is a thing. He is young man. This table is old. That building is decayed. That is an old building. These are the state of things. So anything, state of things. Thirdly, relation of things. See, now this lecture is being organized. Technologically, so many things are related. So we are all sitting in different places. There has been the congregation of software and the hardware, and there has been the relation between various things because of which this event has been possible. So all this webinar is going on is a fact because it is a relation between things. If I write on a chalk, I write with a chalk piece on blackboard, the teacher is writing on blackboard. That is a fact because chalk piece is a thing, I am a thing, blackboard is a thing. There is a relation between. So this is fact. Anything, state of things, relation of things. All importantly, all these three things can be qualified as fact only if these are perceivable by senses. So this is crucial fact. These are perceivable by senses. It means human perception of the fact is essential. That is how whatever we dream of cannot become a fact because we can't have perceived that. Because our senses are not in full force or not working when we are asleep. So those facts or our dreams can't become fact. So this fact is a fact under law of evidence or in the legal sense only when it is perceivable by human senses. So all the five senses must have been working in congregation to say that there is a fact. That is thing. So this is about the fact. There is an addition. Any mental condition of which any person is conscious is also a fact. It means it may not be a fact. It may not be a state, it may not be a thing, it may not be a state of things, or it may not be a relation of things. Even then, something else or mental condition can also be a fact, provided a person is conscious of it. For example, I am having headache. For example, I am very angry. For example, a person is very anxious. For example, a person is very negligent. These are all the states of mind. These are all states of mind. They are also facts because anybody can be conscious of these things. Any rational person can be conscious of these things. So they are also the facts. Okay. Now we have dealt with the definition of evidence, oral and documentary evidence. Plus, within the definition of evidence, we have touched the meaning of the term fact because that is very crucial for our subsequent analysis. Now there is another document that is term which is left out. That is document. What is a document? This is very crucial aspect. Document produced for the inspection of the court and which is in relation to the matters of fact under inquiry is the documentary evidence. All right. What is a document? That term is also being interpreted under section 3 itself. What section 3 says about document is, document means any substance upon which any matter is expressed or described. This substance means it may be a wall, it may be electronic space, it may be a piece of paper. That is a substance upon which any matter is expressed or described. Expressed means written, described means it is being drawn. For example, Google Map. There is a description of the route. There is also the expression of the spots. Google Map is a very good example of a document, electronic document rather. That is an electronic document because it is a substance. Electronic space is a substance upon which a matter is the route and the places in between the places. So these are the matters expressed and described in that on that substance. So this becomes document. The definition doesn't stop there. Further, the document, as I said, it is a substance upon which any matter is expressed or described by what means? By means of letters, words, figures, drawings, etc., etc. maybe the combination of them. For example, the marks card issued to the student, that is a document. There is the means, that is a paper is a substance upon which matter is expressed. Matter is that the result, the marks allotted subject wise, college, signature, everything is being expressed and described. By means of what? By means of figures, words, then logos are there, drawings, emblems are there. So this is a document. The definition further goes, this expression or description must have been with the intention of recording that matter. It means there must be a sort of intention on the part of recorder to record that matter so that it will become a document. Otherwise, it is not a document. There must be an intention of recording it. It means if I am sitting on a sea beach and just to pass my time, if I write my name on the sand there on sea beach, that is not a document. That is not a document because I never intended to record that matter. Suppose I am sitting idly and I write something on the paper without any meaning. Just I draw a line or I make my signature. They are all not the documents because I never intended to record the matter. Suppose a teacher in a classroom. He writes on blackboard. He is not intending to record that matter because he wipes it out immediately. Just at that moment, to convince the students, he writes something. And wipes it out. That may not be a document, but that because he is a document. Now I think I have convinced you about the definition of evidence, oral evidence, document evidence, and the real evidence. And within that is the section 3. There are 3 more concepts which are to be understood before I proceed further under section 3 itself. 3 terms: proved, disproved, and not proved. These terms are crucial because so far I have told you about the fact, evidence of facts before the court. When the evidence is adduced before the court about the facts, that fact may be proved, or the fact may be disproved, or the fact may still be not proved. What does it mean? Because it has got so much relevance in the actual practice of law. Not proved. Okay, proved. When the court considers that a fact exists, when the court, after verifying the records placed before it, if the court considers that a fact exists, then the fact is said to be proved. Or else, the court is not totally convinced, but the court considers it from the point of view of an ordinary person that he considers it to that fact to be in existence, then also the fact is said to be proved. It means the court may agree on its own that the fact is in existence, or the court may come to the conclusion that from the point of view of an ordinary prudent man that fact exists. In the cases the fact is proved, then disproved. When a fact is tried to be proved but the opposite party disproves it, that it is not in existence at all. That is, when the court believes that a particular fact does not exist, or when the court believes that from the point of view of an ordinary prudent man a fact doesn't exist at all, then also the fact is disproved. These are 2 things. I'll give you an example at the end of all the 3. Then not proved. Not proved means a fact is not proved when it is neither proved nor it is proved. It is neither proved nor disproved. These are having very important legal consequences in law. These 3 terms. I'll give you an example. I'll try to give you because most of them are students here, not for the purpose of the experts here. How to understand these 3 terms? Whether I have a 500 rupee note or not in my pocket is the question. If that question is asked to me, if I draw 500 rupees and note and show it to the person who asked that question, the fact of whether I had or whether I possess 500 rupees or not is proved. The fact is proved. Now the question is whether I have 500 rupees or not. Then somebody comes and verifies all my pockets. In none of the pockets, 500 rupees exists. Means there is no 500 rupees note at all. Then the fact that I have 500 rupees is disproved because it is not there at all in all my pockets. It is disproved, not proved. The question is whether 500 rupees is there with me or not. But nobody has made the search, including myself. I have not shown it. Nobody has searched it. So it is neither proved nor disproved. Such fact becomes not proved fact. It has got great importance here. Let me give you an example in actual practice how it becomes relevant. Suppose the court is deciding the question of legitimacy of a person according to section 112 of the Indian Evidence Act. Legitimacy of a person. So the important question to decide the legitimacy of a person is whether that person is born during the existence of the marriage between his mother and any man. This is the fact to be considered. So when a person, whether a person is legitimate or not depends upon whether he is born. Of course, he is born within 280 days and all other things. I'm not going in detail as far as section 112 is concerned. Simple thing, his birth during the existence of the marriage of his mother with any man is the crucial fact to be proved to decide about his legitimacy. Suppose there is no direct proof at all. On the basis of circumstantial evidence, on the public opinions of the people who are supposed to know about their relation, the court has come to the conclusion that that person is legitimate and is the son of that man only, though there is no direct or clear-cut proof of the marriage, because the law leans against the legitimacy. The law leans towards the legitimacy. Because of that broader object, the court says that a person is legitimate, or the court declares that a person is legitimate. But the question is whether the fact of marriage between his mother and that man is proved or not. It's not proved. We have to say it is not proved. If it would have been proved, that would have been direct evidence. But it is not proved here, because if we say that that is also proved, then the questions of granting maintenance and all will arise, about the marital status and all would arise. That is how we have to be very clear cut as to when a fact is said to be proved, when it is said to be disproved, and when it is not proved. That is very crucial in the law. Now this is section 3. To come to that topic of admissibility and relevance, let me also tell you about section 5 very briefly. What section 5 says is, evidence may be given of facts in issue and relevant facts alone and none else. Means the parties who want to adduce evidence before the court must confine themselves to the facts in issue and relevant facts and none else. Means unnecessarily evidence cannot be given on all facts. We have to show to the court that it is in relation to the facts in issue and relevant facts. When I said facts, there are two things: fact in issue and relevant fact for the purpose of proceeding. What is fact in issue and what is relevant fact? So I said, under section 5, evidence can be given only relating to the fact in issue and relevant fact. So let me resolve these two concepts: fact and issue. What is fact and issue? Fact and issue means that fact whose existence or non-existence is going to determine the right or liability in a suit or proceeding. So what is fact and issue? Fact and issue means any fact which is going to determine the existence of any right or liability of the parties in the suit or proceeding. That's very crucial thing. Let me give you an example. Whether I borrowed a loan of 100 rupees from B or not, he has gone to court stating that I have borrowed a loan from him. I am denying it. So the fact and issue is whether M has borrowed 100 rupees loan or not is the fact and issue. This is fact and issue because if the answer is yes, I am liable and he has got the right. If the answer is no, I am not liable. So that is the fact and issue. In civil cases, coming to the example of the criminal case, suppose the person is accused of murder. Whether he has killed that person by stabbing or not, poisoning or not, these are the facts in issue because establishment of those facts are going to decide his liability in criminal case. In civil cases, we find the facts in issue in the issues framed. Issues framed. So in civil cases, the issues framed by the courts of law, they tell us about what are the facts in issue in that case. In criminal cases, the charge sheet or the charges framed by the court, not the charge sheet filed by the police, because the court has got the power of scrutinizing or supervising over that, because sometimes additional sections may come or sometimes some sections may go out. So it is not the charge sheet being filed, it is the charges being framed by the courts of law, which is giving us the idea as to what are the facts in issue in a criminal case. So that is the fact in issue. Now, what is relevant fact then? Relevant fact is nothing but the fact which shows the probability or improbability of the existence of fact in issue. To go by section 3, what section 3 says is all facts delineated between section 6 and 55 are relevant facts. It doesn't tell us as to what is relevant fact. But from the reading of section 11 and also all other sections, we can state that relevant fact is a fact which renders the fact in issue probable or improbable. That is the relevant fact. So let me give you an example. I have borrowed 10 lakh rupees from loan from B. It is his case before the court of law. He has filed a suit for recovery of money from me. So his contention is that I have borrowed 10 lakh rupees from loan from him. I deny that I obtained loan at all. I never obtained loan at all from him. That is my denial. Now, whether I have borrowed loan or not is the fact in issue. If he shows a bond being executed and all, that is the evidence related. The fact in issue. Now, if he shows that the fact of, so that is the relevant fact. So fact in issue and relevant fact, these are the two sets of facts to be verified there under section 5, and the evidence must be confined to these two facts only. And so when we try to adduce evidence before the court will be asking us, show us in what way it is relevant. Explain us in what way this evidence is going to be relevant for the determination of the issue in this case. They will be asking us this question. We should be able to convince the court about that as well. So this is section 5. Okay, with this, we are now clear about what is evidence and on what we are supposed to give evidence before the court of law. There are, as I said, very many facts which are relevant in Evidence Act between section 6 and 55. All are relevant facts only, including the confessions, admissions and all. Now, with this, I think we can briefly look to two sections before we come to that admissibility and relevancy portion. Those two sections are section 101 and 102. Why I am taking out to directly to section 101, 102 is the topic is making me to do so. How it is relevant, I will be showing that. Section 101, burden of proof. There is a definition of burden of proof under section 101. What is burden of proof? The section, that is section 101, tells us when any person wants a decision in his favor from the court of law. I am telling it in general words. I am not going by the terminology of section 101. When any person desires the court to give judgment in his favor on the basis of existence of certain facts which he asserts to be in existence, he must prove the existence of those facts. It means when a person desires the court of law, means he is expecting the court to give a judgment in his favor. Court should give judgment on the basis of existence of certain facts. If it is his desire, he should prove that fact. I'll give you an example. Suppose X wants the court to declare certain properties as his properties on the basis of will executed in his favor. So he wants a decision in his favor on the basis of the fact of a will being executed in his favor. Then he should prove the existence of that will. When a person is under the obligation of proving a fact as per this section, the burden of proof is set to lie on that person. The burden of proof is set to lie on that person. It means this is called as initial burden of proof. I will come to the onus of proof in the subsequent section, that is section 102. Okay, let me tell you that I have told you about the burden of proof. When a person desires the court to give him judgment on the basis of a certain fact, he should prove the existence of that fact. The burden of proving that fact is on that person himself. This is called as burden of proof, either in civil cases or in criminal cases. Coming to 102, onus of proof. What is onus of proof? On whom the burden of proof lies. Section 102 is titled as on whom the burden of proof lies. In any sort of proceedings, if no evidence at all is adduced on either side, the person who would fail, on him there is called as the onus of proof. So there is onus of proof on that person who would fail or who is likely to fail. It means it is subsequent burden of proof, not the initial burden of proof. When the proceedings start, at any stage of the proceeding, if no evidence is adduced on either side, at that time, who is likely to win the case and who is likely to lose the case, we have to determine. Now, the person who is likely to lose, there is what we call as the onus of proof. In common parlance, we say that burden of proof and onus of proof are same, but in literal sense, they are not one and the same. Burden of proof is initial burden of proof and it never shifts. Whereas onus of proof goes on shifting. Let me give you an example. I file a suit to claim certain properties on the basis of existence of a will. It is my obligation to prove the existence of will. It is called as initial burden of proof that I have to discharge under section 101. That is burden of proof. Once I show the will to the court, once I produce the will to the court as evidence, now the onus of proof shifts to the opponent, because if he don't give evidence at this stage, but I have already given the will to the court, then he is likely to fail. He would fail. So the onus of proof lies on him. Suppose he gives an evidence that there is a fraud then the onus of proof shifts to me. I should say that the will is genuine or valid. If the story ends where the decision comes, it is called as the onus of proof. Initial burden of proof is always on the party who asserts the existence of certain fact and he wants a decision on the basis of those facts. That is called as initial burden of proof as per section 101. That is burden of proof. It never shifts. Subsequent burden of proof goes on. So this is section 101. And so I'm sorry. Let me come to the question of admissibility and relevance. What is admissibility? Admissibility and relevance, it is stated that they are the two faces of the same coin. But what I say is, rather it is being established already in the legal literature that admissibility is a question of law, whereas relevance is the mixed question of law and fact. Admissibility is being explained statutorily and by the deciding cases. But relevancy, it is the question of prudence. It is left to the judges. And there are also rules of law regarding this, and it is also the question of logic by the judges. So this is admissibility and the relevance. Now the simple explanation of these two terms is, when any party wants to adduce evidence before the court has to see whether that evidence is admissible or not. If that evidence is not admissible or inadmissible, the court should reject it. The court should not consider it. There is the obligation on the part of court. Then relevance. Once the evidence is admitted, the court has to give relevance to it. How much relevance it gives, it is the discretion of the court. Whether to give relevance or not is the question of law again. Maybe the question of fact as well. Weight, question of prudence, logic. But admissibility is purely the question of law. Now the important thing about admissibility is, in actual courts of law, what happens is, whether an evidence is admissible or not is a very crucial factor in courts of law, because the task of giving judgment after considering or after completing the trial, the process of settling or process of determining this admissibility and assigning relevance to the evidence is a tedious task than the coming out with the judgment itself. That's how the admissibility matter is a very crucial and technical issue in the courts of law. And regarding that, let me take the participants to some 2 case laws, 2-3 case laws, wherein which I'll discuss as to where the present law stands regarding the admissibility and relevance. This admissibility, what happens in the courts of law is, suppose one party tries to adduce an evidence in the form of a document, and the opposite party objects to its admission in the evidence. It is not admissible. There is an objection by the opposite party. Now there will be an IA in the form of objection, and there will be reply to the objection. Like that, there will be hearings after hearings, and there will be lot of time being consumed, and the cases will be dragged like this is all the possibility. So to overcome this, there have been remedies in this statute, especially in the Civil Procedure Code and also in the Indian Evidence Act. Apart from those statutory remedies, which I am going to deal with very shortly, there is also there's also the case law regarding. Let me tell one case law. First one is this Bipin Shantilal versus State of Gujarat. Bipin Shantilal versus State of Gujarat, decided on 22nd February 2001. Old case, but still it's a very good decision by the Supreme Court of India. Decided in 2001, this Bipin case, what the court held in that case was, when there is production of document before the court as evidence, and if there is objection to it, the court can proceed to further stages of evidence after tentatively marking the document. Means pending the marking that determination of the admissibility must be in any case decided at the end of the trial or the proceedings before the judgment. So while reaching judgment, the admissibility issue has to be decided by the court, but until then it can tentatively mark it and the proceedings can run. And this kind of practice by the courts is welcomed, because one thing is the time of the court is saved, because there need not be the time dragging with objections and replies and all, and the proceedings can run concurrently. Time of the court is saved. And another thing is, when the judgment comes, the admissibility issue is also decided, and along with the admissibility issue, the entire matter can be again re-looked in the appeal. That is good in terms of administration of justice. So because of this, Bipin's case provided a very good judgment in 2001. That is Bipin's case. But one exception was cited in Bipin's case. That is, when an unstamped document is produced before the court. That is, there are some documents which are necessarily to be stamped. If there are some documents being produced before the court, as per law, they should have been stamped, but they are not stamped. For example, partition deed, they should be stamped, but they are not stamped. If they are stamped before the court, and if one party adduces them or produces them before the court, if the other party opposes it, or even the court suo motu opposes it, then unless and until the admissibility issue is resolved, because the party is at liberty to pay the stamp duty and get it admitted in the evidence, even before the court. So unless the admissibility issue is resolved, court cannot take up or court cannot mark it. So that is the important exception delineated by the Bipin's case by the Supreme Court of India. So this is Bipin's case. So I said regarding admissibility of a document, when there is objection, it can be tentatively marked and the admissibility question can be decided at the end of the proceeding. That is Bipin's case. Then in 2003, this was in 2001, I said. In 2003, another decision came by the Supreme Court of India, that was in Venkatachala versus it is a Tamil Nadu case, Venkatachala case, it was decided on 8th October 2003. In Venkatachala, what the Supreme Court of India did was, it said as a matter of ratio that if there is objection to admissibility issue, the court should decide it, determine it forthwith and then proceed. It should not keep it pending. The court should proceed on, the court should first decide it. It should not resort to tentative marking and proceed. It should resolve it and then only it should proceed. So that is the decision of the Supreme Court. Supreme Court also categorized objections to such admissibility into two things. One is objection as to very admissibility of the document, then objection as to the mode of proof. Objection as to the admissibility of the document and admission as to the mode of proof. Court said objection as to admissibility of the document can be kept pending. It can even be made during the appeal also. That can be kept open. But objection as to the mode of proof cannot be postponed. It should be decided forthwith. Mode of proof. Now, very recently, in the month of May itself, the decision has come from the Supreme Court about the admissibility of electronic documents. There, what the Supreme Court has said is, unless and until the mode of proof as cited under section 65B of the Indian Evidence Act is resulted, no evidence of electronic documents is to be received in the court of law. That is the decision of the Supreme Court now. It means, in the light of that judgment, now no court can proceed to admit an electronic document unless the such electronic document is proved as per the mode expressed under section 65B. What is stated under 65B? I will come to that later, little later. So that is the mode of proof regarding the that. So there can be objection regarding the mode of proof, which is to be settled at forthwith by the court. This is the ratio. Okay. Now with this, what we can make distinction between the two cases is, in 2001, in Bipin, Supreme Court said courts can proceed to hear the case pending the marking of the document, by keeping the marking of documents in pendency, tentatively marking. But in the other case, the Venkatachala case, Supreme Court said, at least as far as mode of proof, you can't proceed unless you determine or decide the admissibility. Now, is there a clash of ratios between the two judgments of the Supreme Court of India? Which one is to be followed? Which is the better law? Is to be answered by we people. Now, when we consider both the cases, we can reasonably say that Bipin's case is the best ratio. It is the best judgment for some reasons. First reason is that in Bipin's case, it was three judges by the judgment, whereas in Venkatachala only 2 judges were there in that case. So naturally, authority lies more with the Bipin. That is one. Another reason is Bipin's case is a reasoned judgment, because in Bipin's case, a well articulated explanation is given as to why we should proceed tentatively marking the document, because it will save the time of the court and it will also render justice to the people, because there may not be delay in the administration of justice. So that is a reasoned judgment. Third thing, which we can say why BPN is a better law. Under Order 13, Rule 3 of the Civil Procedure Code, Order 13, Rule 3 of the Civil Procedure Code, we have a clear-cut provision that the court can reject any irrelevant or inadmissible document at any stage of the proceeding, at any stage of the suit. So, if a document is found to be irrelevant or inadmissible, the court has got all powers under this provision to reject or not to consider such documents at any stage of the suit. When such a power is given to the court, what is wrong in allowing the or marking that document and looking to its admissibility later? Because throughout the suit, that sort of power is there with the court. So this, in the light of this statutory provision, defense case stands better or good ratio. That is one thing. We can also come to section 136 of the Indian Evidence Act. Examination of witnesses. The court has the power of determining the relevancy of any evidence. When any evidence is tried to be adduced before the court, then the court has got the power of asking questions in what way it is being relevant. If it is not relevant, it can reject it. So it can very well cover the oral evidence. Under Order 13, Rule 3, we can see about the document. Here we can see about the statements made before the court in the form of oral evidence. So they may also be rejected if they are not relevant. So the admissible, if they are not admissible. So this is the Order 130, Section 136, and there is also Section 165 of the Indian Evidence Act. Section 165, to check the veracity of the questions or to determine different factors, judge can ask different questions to test the relevance of or the admissibility of the evidence being produced. When all these checks and balances are there under the statute, there is nothing wrong in getting the document marked at the earlier stage and proceeding with it and deciding it at the time of judgment itself, as held in case. So this is a better judgment in the opinion of many, including me, and it is up to you people to debate on that issue. There is no question about that. Then this is all about admissibility I discussed. Now the question is about the relevancy. What is relevancy and how far it is different from admissibility? Relevancy means assigning some value to it in evidence. Relevant means it is relevant. What is, after all, what is relevancy? When we say that existence of one fact is going to throw certain light on the existence of another fact, then this fact is relevant to that fact. This is relevant to that fact. And usually we say under Section 8, we describe it in classroom that the accused of an offense is found absconding immediately after the incident. So the one fact is commission of offense, another fact is he is absconding. The fact that he is absconding is relevant because it throws certain light on the fact whether he has committed the offense or not. So that is relevant. So relevancy is that. So relevancy is one thing, admissibility is another thing. Relevancy is a mixed question of law and fact. As it is stated at the beginning itself, all relevant facts may not be admissible at all. For example, logically relevant facts. There are many facts which are or evidences which are logically relevant, but they may not be admissible at all as per law. For example, confession made before the police. Logically speaking, that is relevant. Legally speaking, that is not relevant. Because that is not admissible. We can assign relevancy only when it is admissible. So there are logically relevant facts which are inadmissible. So there is a marked difference between admissibility and relevance. So once, even though logically it is relevant, it may be inadmissible. As I said, confession made to the police is inadmissible. Logically it is relevant, but still it is not evidence. Nowadays there is lot of hue and cry about the present day news or today's news itself. For example, two actresses, they are being caught in the drug menace. Now they are being interrogated by the police, and the TV news is telling us that actress so and so agreed or confessed. Actress so and so confessed to have consumed the drug. Is this confession? Logically speaking, yes, but legally speaking, it is not. Because we believe that she has confessed, so she will be convicted. It is not the case. It may not be the case at all, because this confession is not to be proved. There is an express ban under section 25 and 26 Indian Evidence Act to prove these confessions made before the police, unless they are made before the magistrate under section 164 of CRPC. So this is logical. One part I said, a logically relevant evidence may be inadmissible. Another thing is, logically irrelevant evidence may be admissible sometimes. Logically it is irrelevant, but legally it may be admissible. This is possible. During cross-examination, questions may be asked to the witness to test his veracity, totally unrelated question, regarding his other relations, regarding his other transactions, regarding his hobbies, regarding his way of life, regarding his professions, even though they are not in issue or they are not remotely relevant also. That is being allowed because by asking such questions, his veracity can be tested and truth can be elicited from his mouth. This can be the defense of the person who is cross-examining him. So, during cross-examination, logically irrelevant questions may also be asked because they are permitted or they are admitted. They are admissible as per law relating to the cross-examination. So, this is a relevancy and admissibility. Now, as I said, there may be inadmissibility of certain facts, though they are logically related. Let me give some examples about these things in the Evidence Act itself. For example, what I am doing now is I am telling you about the inadmissibility of logically relevant facts. So I am giving you certain examples wherein the evidence is logically relevant but legally inadmissible. What are those possibilities under the Indian Evidence Act? The first one is exclusion of oral by documentary evidence as laid down under section 91 and 92. So section 91, 99 also, these provisions say about it. But for the purpose of understanding, let me take you to 91 and 92. Whenever any matter is reduced into writing either optionally or so there is a writing. When any contents of that document, no oral evidence can be given, only documentary evidence has to be given. It is so given under section 22 of the Indian Evidence Act. So contents of the documents can be proved only by the documentary evidence and not by the oral evidence. So to vary, contradict those contents of the documents, again documentary evidence itself can be given and not the oral evidence. So I'll give you an example how it works in the actual proceedings. Suppose the man has agreed to sell his property for 10 lakhs to the other person. The sale price is 10 lakh, sale agreement, 10 lakhs is the price. The deed is executed. After that, now after 6 months, there is some sort of agreement between them whereby price is orally agreed to be 12 lakhs in place of 10 lakhs. So the purchaser has agreed to give 12 lakhs instead of 10 lakhs orally, but not documentarily. This is an agreement between them orally. Subsequently, vendor claims 12 lakhs, but the vendee is ready to give only 10 lakhs. Who will be successful? Definitely the vendee, purchaser, because the matter is reduced into the writing, that is 10 lakhs. When it is so reduced, to contradict these terms, we can give at best only documentary evidence and not the oral evidence at all. Logically speaking, what have agreed orally to give 12 lakhs instead of 10 lakhs is correct. That is relevant, logically speaking. But in law, it is not admissible. So this is one example. The other example is estoppel, section 115 to 117. When any fact is admitted, the party who has admitted that fact, he is stopped from denying the truth of that admission. So when a person is bound by estoppel, even though he has got a logically relevant fact to prove, it will not be admitted at all. Suppose I am selling a property for which I am not an owner at all. I am selling this property to another person. I am not the owner of that property at all. Subsequently, I get the ownership of that property. And when that person insists to hand over that property, if I say that no, when I sold that property, I was not the owner of that property, I am stopped. Estoppel is applicable to me. Logically speaking, at the time of sale, I was not the owner of it. So logically speaking, my argument is correct, relevant, but that won't hold good in the light of the law laid down under section 115 to 117 of the Indian Evidence Act. So that is second example wherein logically it is relevant, but legally inadmissible. The third is the set of communications called as privileged communications. Let me take only one example. The person is accused of theft, and there is an evidence to show that immediately after the alleged incident, he has stolen them and hide them to somewhere and all, etc., etc. This is a statement made by him. Now, when he is so accused before the court of theft, his wife, he cannot be compelled to be a witness against himself because the law prohibits it. These are called as protected or privileged communications under section 122 of the Indian Evidence Act. So, privileged communications, though logically relevant, they cannot be proved because they are inadmissible as per law. That is the third set of facts. These are the examples as to how there may be logically relevant facts, but legally they are inadmissible. And this is how there are the admissibility and this relevancy are to be distinguished from one another. So this is about admissibility and this relevancy. Now, before I conclude, let me within 3 to 4 or 5 minutes, let me also discuss about this admissibility and relevancy of electronic documents, because of the recent judgments, several judgments, there has been some confusion, and ultimately the Supreme Court of India has tried to settle the confusion in the recent one. In my view, even then the confusion is not as settled, because the Court of India, Supreme Court of India, is not touching upon the real issues before the lowest court. What is happening there? And unless we touch upon the real issues faced by the lower court and settling this issue, I think the proper ratio or the perfect ratio can't be established in this matter. Okay, what is this admissibility and relevance of electronic documents? Section 65A. As I said, I told you about what is documentary evidence. In documentary evidence, there are two types: primary evidence and secondary evidence. Plainly speaking, primary evidence means the document itself is produced for the inspection of court. That is called as primary evidence. There is again definition of primary evidence, which I am not going to discuss. What is secondary evidence? When copies made from the original, etc., certified copies, etc., are produced before the court, they are called as secondary evidence of the document. Section 65 of the Indian Evidence Act clearly states as to when, in what cases, the secondary evidence relating to a document may be allowed or permitted. So, Section 65 tells us when secondary evidence relating to the document may be allowed. So, unless and until we justify our secondary evidence production under any of the clauses under Section 65, we can't adduce secondary evidence relating to the document, because we have to produce only the original document itself for the court. As far as electronic document, by virtue of the amendment, Section 65 and 65B are state. Section 65 and 65B, 65A and 65B, what they say is, when electronic document is being produced before the court, that is also to be regarded as document. That's all okay. How to prove it? As per section 65B, it should be proved before the court. It may be proved before the court. What section 65B provides? There's no need to go in detail about this section. Section 65B. It defines as to what is electronic evidence or electronic document. When any matter is recorded digitally in computer, stored in computer, etc., etc., that is an electronic document. Then what is the original evidence of it and what is the secondary evidence? I mean, what is primary evidence of it and what is secondary evidence of it? When the computer itself and the device itself is produced to the court, it is primary evidence. If the copies are derived from the computer and printouts are taken and produced before the court, that is secondary. This much we are sure. Now, what happened in this, when statute was so provided in 2000, in 2005, in Navjot Sandhu case, what the court said was, the court said, is by the decision of High Court, the court said, even regarding the electronic document, secondary evidence as laid down for the other documents can be given. So no need to go for section 65B at all. That was so decision, erroneous decision came out. And to overcome this hiccup created by the decision of the High Court, Supreme Court arrived at a decision in Anwar versus Bashir in 2014. In Anwar versus Bashir, the Supreme Court said one thing, it made clear that as far as electronic document, secondary evidence or primary evidence, it can be given only in accordance with section 65A and section 65B and not in accordance with 63 of the Indian. You cannot follow the rules of secondary evidence as regards ordinary documents. You have to follow only section 65B. Then what section 65B says? Under section 65B, as I said, there is computer as primary evidence. When copies are taken from the computer digitally or in the form of printouts and all, the law says if that device is in the control of some other person, and if that device can't be brought to the court, etc. and all, in that case, the person who is in control of that device and the person who has created the document, etc., etc., a certificate has to be obtained from that person, and that certificate has to be appended along with these printouts for the purpose of producing secondary evidence relating to the document. This is so stated. Now, when it is so stated, now the question remained. There is another question. The problem is, in family courts especially, in divorce matters, cruelty is being alleged. What happens? Suppose husband sends abusive messages to the wife over mail or WhatsApp or Insta, etc. Wife also does the same thing. What these people do is, suppose wife has received abusive messages over Instagram or over mail, etc., etc. What she does is, she puts everything into the computer and she translates how she gets them in the form of a printed copy and produces it to the court. So, to whom the device belonged? The mobile belongs to her. Her laptop belongs to her. Printer belongs to her. Then whether she should enclose a certificate, the law so far is not clear about it, in my opinion, personal opinion. So, see, as a matter of formality, as said in Anwar versus Bashir, and also as stated under section 65B, she attaches her own certificate that this is true and all, borrowed from my own system and all. She attaches an application, gets rid of that process. Now, is this the correct process? Is the question. Now, that question is tried to be answered by the Supreme Court in a very recent judgment, that is Safi Mohammed versus State of Himachal Pradesh. That was in 2018. The very recent decision in 2020 is Arjun Pandit Rao case. In Arjun Pandit Rao case, the Supreme Court now what it is stating is, when you are creating the document on your own in the devices, only the device itself can become the primary evidence. The device itself has to be produced. When the device is in the control of some organizations or institutions or some other person, legally speaking, and they are the owners of it, then in that case you have to obtain the copies plus the certificate. For example, we take the printout of this, we download the copies of Aadhaar and produce before the court. It is valid because the law says Information Technology Act, digital signature and all. This is a valid document. No need of verifying the signature and all. Such is the proof being guaranteed to us. So this is how regarding electronic documents now. Still there is a lot of confusion. When if I want to produce something out of my own mobile, if I take a print of it and if I produce it in the court of law, the courts should insist for the production of the mobile itself to the court. In fact, if at all I have understood the provisions of section 65A and B and the recent Supreme Court decision properly, that is my individual view. So this is all about the documentary evidence. And I was given with the topic this admissibility of evidence and the relevancy of the evidence. I tried to cover different issues. The act is was within 1 hour, all the things can't be covered. I did my best. With this, I am concluding with an option to the participant to place their questions to the organizers, and in turn they can ask them to me. And I am wholeheartedly thankful to the organizers, especially the principal, IKC coordinator, and the coordinators of the different communities, and also the management of the Saraswati Law College. Thank you very much. Over to the anchor.
Thank you, sir, for giving your valuable insight on law of evidence, along with the very good examples and recent case law. Sir, I am sure your address will help a lot in understanding the conceptual differences between admissibility and relevancy, and also electronic documents. Thank you, sir. We will go ahead and take some time for questions now. And for this, I would like to hand over this session to Mr. Karyana KS, Assistant Professor, Saraswati Law College, Chitradurga. Over to you, sir.
Thank you, madam. Good afternoon, everyone. As it was instructed to the participants, ask the question through chat box. Few participants asked question through chat. I think the is covered on the answer all those, but still I bring to the notice of this the few questions. Is Madhuka, can electronic DVD that is complied according to section 60B to P machines PN Nuar exhibited and added in trial court. The presiding officer does not appreciate it on the text. The APP, that is the public prosecutor, failed to the court regarding that evidence. What is your takes? Sir Matolli, sir. Matolli, sir. Sir.
Yeah, please.
Sir, audible.
Hello, madam. Start.
Sir.
Please.
Sir, it's not.
I'll mute my video. Okay, I'll answer your question.
Okay, sir.
I'll mute my video. You can place me the questions.
Okay.
I'll answer them.
Okay.
Yeah, please.
1 second to read out, sir.
Please ask the questions.
See, yes, the question is from Kumukara. Electronic document PD combined up to section 65B into PV Bashir's PVR exited, marked, and admitted in trial court. The presiding officer does not appreciate it on the pretext. The assistant public prosecutor failed to convince the court regarding that evidence. What is your take, sir?
Okay, if I am correct, because there is some audibility problem, I'll tell you as to what the question is. The question is regarding the admissibility of the recorded evidence that is in the police station. CDs are being created about the evidence. That is the statement. The statements, is it correct? That police station and is in the form of audio. About that, the take, no?
Sir, regarding DVD, sir.
DVD is being produced to the court.
Sir.
DVD is produced, yeah. The whether 65B compliance is made or not is the question. Okay. First, the thing to be understood is it passes the test of 65B because that DVD is submitted along with a certificate from the police that it is so made from their computer in the police station and so on and so forth. So there is not an issue. So it passes the test under 65B. The question is whether the contents of that DVD are admissible or not is still the question open because the statements made before the police are not admissible as confessions. If they are pertaining to the confessions, they are not admissible. If they are relating to the something else, then they may be admitted. Yes, next question.
Sir, regarding second question, I think you have already answered question. Dr. K.S. Kumar asked that question. I bring your notice that all admissible evidence is relevant, but all evidence not admissible. I think you have already answered for this question, sir. I will go to the next question. That is again from Kumar Madhukara. Can the presiding officer of a trial court deny appreciation of admitted electronic evidence which is written on the text? The prosecutor failed to convince the court. Please evaluate.
Okay, prosecutor. See, the question I think, where can the court suo moto take into account the evidence produced in the form of electronic document to the court? That is the question. Even though the prosecutor is willing to applicate it to the court, the courts can suo moto, they have got the powers to verify the document because very definition of the evidence in terms of documentary evidence, it says documents means they are the documents produced for the inspection of the court. The court has got the right to, or it has got its total power to inspect the document. Means it has got every power to appreciate it if it finds so.
Okay, sir. Thank you very much.
Please, next question. Next question.
Sir, that is the last answer. Over to you, Arsham.
Yeah, please.
Thank you, one and all. I now request our beloved principal, Srimati Professor M.S. Sudhadevi, to give the vote of thanks.
Sir, Law College coordinator of the Shaila, Sir, Dr. B. Ravi Kumar, Sir, Dr. S. Karina, Assistant Professor, and my other colleagues and all the participants. Today we have got an opportunity to organize a national webinar on the relevancy and admissibility of evidence. Though admissibility of evidence and relevancy of evidence are synonyms, but both are different. As earlier said by our honorable speaker, that they are the two faces of the same coin, but they are different from each other. Relevancy of facts are genus and admissibility of facts are species. Relevancy is based on the logic, whereas admissibility only relies on the lawful pertinence. The admissibility of the fact by the court, admissibility of the fact by the court. Sometimes logically, the speaker said that sometimes logically relevant evidence may be inadmissible and sometimes an irrelevant evidence may be admissible as per law. Relevancy is a question of fact, and it is the duty of the lawyer to decide whether to submit such evidence in the court or not. Admissibility is the the court decides whether it is admissible and should be received by the court. So in the beautiful lecture, Dr. Matolli sir has explained with the examples and also with the decided cases, relied upon the decided cases, the beautifully what is the admissibility of evidence and what is the admissibility of, relevancy of evidence. So the Honorable Speaker, Dr. Matolli, who is a well-wisher and closely connected to our institution, and he is also a subject expert, and he has accepted our invitation. He has given his precious time precious time, and he has given a beautiful lecture on the relevancy and admissibility of evidence. We are very much pleased for his participation, and also his lecture is very informative and also useful to the lawyers, law students, and the law faculties. Sir, you spent your time with us today by delivering a very good lecture. I extend my heartfelt thanks to you on behalf of our management, that is Saraswati Education Society and also Law College. And I extend my heartfelt thanks to the coordinators, Sri Shaila, Dr. Ravi Kumar, Dr. Karyana, and other my colleagues, Sri Sadiq Suhil Ahmad, Srimati Harsha, and Sri Ramesh, and also Dr. N.D. Gowda for their active participation and their effort in organizing this webinar very successful. I also extend my heartfelt thanks to the participants, faculty, students, and also advocates, media persons, and also the public who have participated in this seminar. Thank you, one and all.
Thank you, ma'am. Thank you, everyone. Unmute, ma'am. ಈಗ ಮಾಡಿದ್ದು. Hello, everybody. I request all the audience to submit feedback, fill up the feedback form, and please send it to the link so that you can receive the e-certificate. Thank you.